Hey everyone, this is Matt at the Patriot Party, and today we have one heck of a show in store for you. You guys and gals can expect an exciting interview with Mr. Tanawah Downing. He's a national civil rights advocate and litigator who is leading numerous initiatives intended to change the way in which justice is administered nationwide. Y'all can find Mr. Downing's website link in the description page for this podcast. Please check it out. He is doing some awesome work focusing on the principles in which America was founded. This aligns perfectly with the Patriot Party's movement. Now let's give a very warm welcome to Mr. Tanawah Downing. It's a pleasure to have you on the show.
Thank you, Matt. Thank you for having me. Thank you for having me.
Absolutely. So tell us a little bit about yourself.
Yeah, so the first portion of my life, I spent working for government. I was high up in national security and building threat mitigation systems that was designed to protect the government from the people. Uh, but about 9 years ago, I realized that I was on the wrong side. What we call national security today is simply code word for domestic terrorism because you do not protect the government from the people or the people from the government. You protect people, the government from the people, or vice versa. Anyway, so the issue at hand is that after September 11th, we had a bunch of knee-jerk overreactions that resulted in a massive deprivation of some of our most precious and fundamental rights. And when I went through this very, very brutal divorce back in 2016, what happened to me was, prior to that, I owned a big engineering firm. I was, again, advising on very large scale transportation security solutions for airports and seaports. And I was making 870,000 a year and believed that I was doing the right thing. But when I started suffering as a result of my experience within the system, and having a law background, law enforcement in particular, and substantive law, having that background, I realized that this is not consistent with the American principles. It's not consistent with everything I had been educated. And I realized that there were a lot of people around me that were suffering that weren't supposed to be, and I needed to get my perspective right. And so I went into civil rights litigation full time, building what has now become the biggest civil rights case in American history. It's hands down. It's massive, and can't wait to tell you about it.
Oh, I can't wait to hear about it. Before we get to that, one, I can fill you on a really bad divorce. I went through one of those almost a decade ago, and it was literally like a lifetime movie. We had three judges in one courtroom. We made North Carolina case law. I was spending $26,000 a month on a team of attorneys. It was crazy. So I can feel you there.
Yeah, yeah.
But when you said about the knee jerk reaction, I'd like to get your take on, are you speaking of things like the Patriot Act and the FISA Act and those things that violate civil liberties?
What 100%. You know what? One of the issues with the Patriot Act is that you got to look at our government and how the government and the limitations of powers were divided. The states were responsible for what's called police power. That's why policing and criminal adjudications were meant to be done within states. And that's why Article 3 of the Constitution says that the trial of all crimes, with the exception of impeachment, shall be by jury, and that trial shall occur in the state or in which the crime is said to have been committed. Because people in the United States, we didn't delegate the authority for the central government, the federal government, to adjudicate crimes. And yet, we have an entire justice system that is, locking people up within the central government. But that was not what was designed. That's not what's in the Constitution. And there was a clear limitation of powers that was designed to be able to protect the individual liberties of the people, codified in the Constitution. The central government was responsible for what's called war powers, not police powers, war powers. And so those are two vastly different things. But what happened was that with the Patriot Act, you know, we we didn't pay attention, or at least our legislators didn't pay attention when they were going in to vote on it. And what it did was it actually granted states with war powers. It delegated that. So now that's when we started seeing this ramp up of this militarized, police force across the country, with tanks and armored vehicles and automatic weapons and grenade launchers. I mean, literally, this was the militarization of the state police forces that were then activated as as standing army amongst us during peacetime, which again is also in violation of the Constitution. But that there's a lot of different things, but that's one of the scariest things that I've come to realize is that why is it that we have militarized police, all across this country, and it's the result of again those actions. But also another thing is that during the war on terror, which obviously was what initiated or what came from the Patriot Act, in the war on terror, we had a system that was going out and identifying enemy combatants, right? This was a person that our government believed was a terrorist or a terrorist suspect. And so what they were doing was they were accepting a single narrative. An accusation would come into the CIA or other agency that this person would be a terrorist, and they wouldn't validate that information. They would just simply take that information, go out and find that person, and then they would bring him into this facility that we had down in Guantanamo Bay, Cuba, called Camp X-Ray. And what they did was they presumed that they were guilty based upon the accusation of being a terrorist, and they would put them through these horrible deprivation tactics, which would mess with them physically, emotionally, and so on, physically. And what was happening was that it was actually changing the person, right? And we would keep them with these tactics there, waterboarding and other things, until such time as they just finally admitted that they were what we believed that they were. So we were saying to the terrorists, well, we know you're a terrorist. We know that because we have the information on you, and we're going to put you through these brutal tactics, and we're going to continue to put you through them until such time as you finally break down and agree that that's in fact what you are. But my point is that hindsight, looking back on this, and at the time I was working for intelligence agencies, so I'm very well equipped to be able to speak on this. But what we've learned, hindsight, is that many of the people we put into Guantanamo Bay, Cuba, they were not terrorists when they got there, but they absolutely were when they left there because of the tactics that we were using. So we were making them into the very objects that we wanted them to be based upon the deprivation tactics that we used in order to justify this war on terror. And the reason why I'm bringing this up is because what I'm fighting, what I'm litigating is that those exact same deprivation tactics that we employed down in Guantanamo Bay at Camp X-Ray on these terrorist suspects are the exact same tactics that every single jail and prison used across this country every single day. And what's happening is that we're taking people that are already susceptible, already have some mental health issues, already weak, and we're putting them through horrible, brutal tactics that is designed to make them into the very object that we say that they are, so we can justify this war on crime. And we've got to stop this immediately because there's a much better way to treat our people than to force them into involuntary servitude so that they can go and labor for the direct benefit of the state and for-profit business such as Northrop Grumman, General Dynamics, Victoria's Secret, McDonald's, or many others who I am actually advocating on behalf of.
I love to hear you say that, but one of the big issues that I had, and I think a lot of people had, was not just the Guantanamo Bay thing, because that could be argued one way or another, but it was when these overzealous prosecutors started using this very ambiguous law uh, to prosecute and deny civil liberties, due process from American citizens for regular crimes. Like they would
Yes,
take drug dealers and use the Patriot Act, and then they wouldn't allow them to speak to counsel or any of these civil liberties because you have these overzealous prosecutors who misuse these
yes.
ambiguous laws. And, that's why we like to say at the Patriot Party, ambiguous laws breed bureaucratic overreach and judicial activism.
Yeah. Yeah. And that's a perfect lead in, actually. The only reason why I brought up Guantanamo Bay is because I wanted to provide a little bit of background and history as to, what you're now talking about, because you're absolutely right. We have overzealous prosecutors that believe that people are guilty, right? Because they have information, right? We've been told that you're a drug dealer. Therefore, we're going to prosecute you for an arbitrary or capricious allegation, and we're not going to give you the civil rights that you're entitled by your birthright codified in the Constitution of the United States. So, if I could, let me just explain what it is that I'm actually litigating here, because that's a perfect lead in.
Absolutely. Go for it.
Yeah. So the Constitution of the United States of America is the overarching requirements that every state must follow. No state can create its own alternative legislation and substitute that for the guarantees of the Constitution, go out and enforce that as though it's lawful. Because the Constitution provides the limits of power placed upon all governments, state and federal, in order to preserve the individual liberties of the people. States cannot exceed the power authority statutorily conferred upon them by the Constitution, nor can they eliminate or ignore the restrictions placed upon them. So, Clause 1 of Amendment 5 to the United States Constitution, guys, the Bill of Rights is the first 10 amendments. That was adopted and ratified on December 15th, 1791, in all intents and purposes by the people of the United States. No one is arguing with me on the fact that Amendment 5 is part of the Constitution. But Clause 1 of Amendment 5, welcome you all to go out and read it. It says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That's pretty clear. You better have an indictment by a grand jury before arresting someone and holding them over for a capital or an infamous crime. Now, a capital crime is any crime punishable by a death. It's pretty easy. An infamous crime is any crime punishable by more than 1 year imprisonment in a penitentiary. So if you can get a year and a day, that is an infamous crime, triggering the requirement, the constitutional obligation for the indictment by a grand jury restriction, right? Because you cannot be held to answer for an infamous crime without an indictment by a grand jury. So, uh, again, no state can create its own alternative legislation, substitute that for what the Constitution restricts, and then go out and enforce it. But the problem is that today, right now, as we speak, there are more than 700,000 people that are currently imprisoned across America that never received an indictment by a grand jury, despite the fact that it's required by the Constitution of the United States of America. The reason why is because, going back to what you said, the prosecuting attorneys believe that they don't have to provide the indictment by a grand jury, and that they're able to use their discretion to choose to charge by what's called information or indictment. Now, information is not an indictment. Information, according to federal law, can only be used as the charging instrument for non-infamous crimes, for misdemeanors. And yet, the state of Oklahoma, for instance, its constitution, inferior constitution, Article 2, Section 18 says that the prosecuting attorney can charge by information or indictment by their discretion. So the state of Oklahoma permits their agents to use a different charging instrument than what the Constitution of the United States of America requires, and able to proceed under their discretion. That law is absolutely unconstitutional. Absolutely. For two reasons. One is you can never use your discretion with regard to one's constitutional obligations. Otherwise, what you're doing is you're using your discretion to break the law, and that's an abuse of discretion. And by the abuse of discretion, it nullifies and renders void any action. The second problem is that no state can create a law that allows for their public officials to decide who gets a constitutional right and who does not. That would be a direct violation of the 14th Amendment's Equal Protection Clause. So the way that Oklahoma's constitution functions is unconstitutional, which means that every single time that they perform an arrest, through a prosecutor's abuse of discretion, when they choose to rely upon an inferior state statute that permits them or directs them to break the Constitution of the United States of America, that arrest is unconstitutional, and therefore everything deriving from that arrest must also be unconstitutional. Now, that's issue number one. But there are many other states, 13 of them to be exact, that do not conduct a grand jury at all, including the state of Washington, the state of Connecticut, the state of Pennsylvania, the state of North Dakota, the state of Michigan. These are states that are acting in direct willful defiance of the procedures and processes codified in the Constitution of the United States of America for the adjudication of crime. And let me give you an example. So again, the Constitution, Clause 1 of Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Washington State's Constitution, Article 1, Section 26 says, no grand jury shall be drawn or summoned in any county. So now we have the United States Constitution that says you must have an indictment by a grand jury before holding someone over, and yet the state of Washington has an inferior provision in its inferior constitution that says we're not going to do it. We're not going to do what the Constitution requires us to do. And now we've got a supremacy issue that we need to address, right? This is a big, big deal because, again, there's more than 700,000 people that are currently in prison here in America that never received an indictment by a grand jury, despite the fact that that is a constitutional obligation to initiate a criminal action. So, there is much more to what we're doing, but the
Let me
base of
ask
it
you
is, yeah, go
let
ahead.
me ask you this real quick before you get going in any other, because this kind of coincides with what you're saying right now. So I understand this is like a Fifth Amendment jury clause like challenge. But what I want to know is how you're going to get over the Supreme Court ruling in the 1880s, the California versus Hurtado or whatever, where they
Yeah.
say only the states are only responsible for the due process clause, which does not mandate grand jury indictments. How are you going to get over that?
So first off, in 1884, what happened there was that the state of California had created a provision in its inferior constitution that says we're going to charge by information, not indictment. Now, let me tell you what an information is. An information is when a government official, public official, police officer, uh, let's say that he does a lawful search on you and he finds drugs on you. Well, that police officer can't be your accuser because he works for the state. He has a conflict of interest, and the state would be prosecuting him. So the state of California wanted to be able to prosecute people based upon an accusation from one of their agents. So instead of having a living human being being your accuser, they wanted the state to be able to be your accuser. So that officer then takes information, reduces that information to writing in the form of an affidavit, and then he brings that to a judge. And he asks a judge to determine whether or not there is sufficient probable cause to assume that a crime has been committed. There must be probable cause before you can hold someone over for an offense. But that officer brings that information to a judge and asks a judge to determine whether or not there's sufficient probable cause. The problem is that that officer, that judge, the prosecutor, they all work for the same entity, and that entity just so happens to be your accuser, the moving party, the state of whatever. It is the body of men that make up the state. And when one part of the body of men bring an accusation against you, another part of the same body of men cannot be presumed to be neutral and biased to act as the judge against you, which is why our founders put into place what is called a grand jury. And a grand jury is 16 to 23 people who are impaneled into a jury that do nothing except for review the state's case and the state's accusations to determine whether or not there's probable cause to assume the crime has been committed. It is a check on prosecutorial and state power to make sure that they're not exceeding the power authority statutorily conferred upon them. And when you mentioned overzealous prosecutor, the grand jury, that is the sole function of the grand jury. The purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. So when a prosecutor brings unfounded information against you, unfounded accusations against you, absent the grand jury, absent the fair and neutral third party decision maker to review the state's case, we end up with a whole bunch of people that are not guilty, that maybe there's not even a crime was ever committed, and yet they're being prosecuted, threatened, and intimidated, forced into jail, held there until such time as they finally admit that they're guilty of whatever the prosecutor is alleging they committed, with whatever punishment the prosecutor demands. We must have a fair and neutral decision maker in the process, and information does not facilitate that. And that's precisely the reason why our founders wrote in the Constitution a requirement for the information. Now, going back to your question, 1884, the state of California had in their inferior constitution a provision that says we're going to create information. They created the concept of it. We are going to charge people by way of information. We're not going to charge people by way of indictment, even though the Constitution requires it. Mr. Hurtado then challenged that particular state action as a deprivation of a fundamental rights, saying that the state doesn't do what the Constitution requires. And the United States Supreme Court, under a very, very biased Chief Justice Waite, a train wreck, a science experiment at best, he put into place rulings such as Plessy versus Ferguson, which was a segregation in the South, right? We know now in hindsight how terrible that really was. This was a man that wanted to see the proliferation and advancement of the slavery institution because he was highly sympathetic to it. But nonetheless, he put into place terrible rulings that were outside of the law and the intended purpose of the law as stated within Congress when they were brought into place. But what the court decided there was they said that California does something different, and that's okay. They don't have to do what the Constitution of the United States of America requires them to do. And so the issue here is, and this is the question, because we have two issues that we got to get addressed with this. First off, does the judicial branch have constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution? Does the Supreme Court have the authority to amend the Constitution of the United States of America? And the answer is absolutely not, because the
Mm-mm.
special amending procedure of Article 5 dictates the way that it must be changed, and that has nothing to do with judicial fiat. The only
It's super.
way the
Go
only
ahead.
way that you could change the Constitution is through an authentic and explicit act of the people in accordance with the special amending procedure of Article 5. And that was even stated by our founding father, George Washington, in his farewell address, where he said that those restrictions are sacredly obligatory upon all, both individually and collectively, until changed by an authentic and explicit act of the people. The Supreme
In
Court of the United States has
it,
no authority whatsoever to remove any of the fundamental protections of the people, because what they did there in 1884 was they amended the Constitution of the United States by removing and eliminating the restrictions, and then they put into place what they called law, case law, right? Case law. But the issue there is once again, just like the judicial branch, even the Supreme Court, the judicial branch has no constituted authority to amend the Constitution. If the Supreme Court doesn't like how they have to do business, that's fine. Present your case to the people, get them to amend the Constitution in a lawful manner. But if you don't, then what you just did was you amended the Constitution. You overstepped the separation of powers. You legislated from the bench. And we know from Clause 1, Article 1, that all legislative power is vested in Congress, not in the judicial branch. So when the Supreme Court created a ruling and erroneously called it law, well, that can't be law, brother. It can't be, because judges cannot create law. And when they created that law, they told all the states, including the state of California, you don't have to do what the Constitution requires you to do. And all the states just believed the bullshit. And when they believed the bullshit, then what happened was other states started enacting provisions in their constitution that says we don't have to do it because the Supreme Court said we don't have to do it, even though they are bound and obligated to the Constitution and not to a judge-made ruling. So the second issue that we have to address here, behind the judicial branch, is do states have the right to create their own alternative legislation, substitute that for the guarantees of the Constitution, and go out and enforce it? And the answer there is also no. The state of California had no authority to be able to create its own alternative legislation, substitute it for the guarantees of the Constitution, and go out and enforce that as though that's law. And yet that's exactly what has happened. So the case Hurtado, uh, it's a lie, and it can't be valid because the Constitution is the highest form of law. A judge-made ruling is the lowest form of law. So if the lowest form of law has the power to be superior to the Constitution of the United States of America, the highest form of law, then that means that we are not living based upon the Constitution, but instead upon whatever any judge says is law, and judges cannot create law. So my litigation is actually attacking the Supreme Court and they're overstepping the separation of powers, where they believe that they're able to create judge-made rulings and have those rulings amend the law. We don't follow judges here in America. We follow the law, right? And if judges, disagree with that, they're welcome to go back to England, because in England, the king did delegate the authority for judges to speak law, but we did not do that here in America through the delegation of powers in the Constitution. Judges don't get to speak the law; the people do.
Yeah, I'd like to just touch down on that for just a minute, and you can correct me if I'm wrong. But I mean, it's the Supreme Court's sole purpose is to interpret if laws are constitutional and if laws are valid. Correct? I mean, they have to use the Constitution as a compass. They can't
Right?
alter it. If
Great
you
point. Great point. Absolutely. I mean, the Supreme Court. cannot declare the Constitution unconstitutional because the basis of the comparison is the Constitution. So when they go to the state of California, they say, California, your law is constitutional, right? And even though it's the direct opposite of what the Constitution of the United States of America says, those justices are impeached because their sole purpose was to preserve, protect, and defend the Constitution of the United States, and yet they decided they were going to side with a state constitution and allow for states to be able to act contrary to the Constitution of the United States of America. It is completely bullshit. But I do want to say that you mentioned the due process clause of the 14th Amendment. That is what the court used to make their BS ruling in 1884 with Hurtado. But what that says, it says that no state shall deprive any person of due process of law. The issue is that for years we didn't understand what due process of law was because it was whatever that chief justice in his court decided it was going to be. If they wanted to have it be a part of it, it was a part of it. If they didn't, they say, oh no, that's not part of the process. There's no defined definition of what due process of law is. I'm going to tell you, I didn't use the due process clause of the 14th Amendment for my legal argument, for my litigation, right? Because I already knew that due process was a dead compass, right? It would be whatever they want it to be, and it would be very difficult for me to say, oh, that is, when they can just say, no, it's not. So what I used was I actually used the privileges and immunities clause of the 14th Amendment because that is defined. What that provision says, it says that no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. Abridge means to reduce, diminish, or take away. So no state can create or enforce any law which shall reduce, diminish, or take away any of the privileges and immunities of United States citizens. Now, bear in mind that that provision was created and adopted by the people in 1868. The Hurtado case was in 1884, years later, 20 years later, right? So we already had a law that said no state can create or enforce any law which shall abridge the privileges and immunities of the United States citizens. And yet the court came out and said that state created a law and is enforcing it, which abridges the privileges and immunities of the United States citizens. And the reason why I say that is because in 2019, we had a ruling from the United States Supreme Court called Timbs versus Indiana. That's Timbs versus Indiana. And what happened there was that Mr. Timbs was he had excessive fines that was being applied against him from the state. So he challenged it to the United States Supreme Court. He said that he's protected by the excessive fines clause of the Eighth Amendment and thus seeking, protection under his fundamental rights. And the court came out in 2019 in a unanimous decision. Six of the same justices that we're dealing with right now today on what I'm doing, six of the same justices, unanimous decision, and they said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by states because of their codification in the Constitution's text. So, in other words, if it's written in the Bill of Rights, if it's enumerated within the Bill of Rights, that is at a minimum what the privileges and immunities of every single United States citizen. And I understand a lot of people, perhaps some of your viewers might not like that term, but I have to go on certain presumptions, and the presumption that I'm going upon is that the 14th Amendment is valid, and that we can rely upon the citizenship. If it's determined that the 14th Amendment wasn't properly ratified, that's fine, but government's going to have to make that decision and direct us in that direction. We have to move under certain presumptions, and the presumption I am moving under is that the 14th Amendment is valid, it was ratified, and we can rely upon the privileges and immunities clause because the Supreme Court already said that at a minimum, every single United States citizen is guaranteed what is enumerated within the Bill of Rights. The Fifth Amendment is absolutely 100% without a doubt enumerated within the Bill of Rights. Therefore, it is protected against interference by the states because it's codified in the Constitution's text. So when we went with this, we went with the privileges and immunities clause because we do have a definition of what is a privilege and immunity for a United States citizen, and that is whatever the Bill of Rights has written in it. We have an absolute winner. We have six of the same justices that made that decision in 2019 that can't change what they said now, right? And this is written for all to see. And I just want the people of the United States to get the rights they're guaranteed, because today anyone can be arrested for any arbitrary or capricious information collected by any state official, public official, law enforcement. They can arrest you for anything that they want. They don't have to investigate, and they can lock you up in a jail and hold you in that jail until such time as you finally admit that you did what they said that you did. They're using threats, intimidation, coercion, and duress in order to get you to enter into a contract with them so you can act as a witness against yourself for whatever arbitrary or capricious allegation they brought against you. And this is not the way that this system was designed to work. Not the way it was designed to work.
Before I was going to ask you something, I'm going to hold off for just a second. Before we go forward, I'd like to ask your opinion on something, because you've spoken of some capricious things that go on and how they maneuver in the way that they do, which is not good. Um,
Yeah.
are you familiar with trial tax? The
Child
trial
tax?
tax. The
A
trial
little
tax,
bit. Yeah.
yeah, where you people who want to exercise their constitutional right of a trial by jury are told, well, we'll give you a 5-year plea, but if you bring it to trial, when we convict you, we're gonna give you life.
Right. Right. So what I would say to that, and what's most important, is that a maxim of law is you cannot be punished for having a right. Government can't punish you for having to fulfill an obligation. So if the obligation of government is they must find someone guilty by a trial by jury, right? Then when they come to you and they say, well, if you don't plead guilty, I'm going to take you to trial and I'm going to ask for 20 years, right? But if you plead guilty, we'll let you go today. Are you not being punished for the obligation that they have? Are you not being punished for having a right? Right? If you if you have them actually fulfill the lawful obligations that they have, are you not being punished for such action? That is absolutely contrary to constitutionalism. That is a crime, and it's called extortion. So extortion and robbery are extremely close together on the criminal spectrum, you guys. Extremely close together. Robbery is to formulate a contract through illegal means with the threat of immediate bodily harm. Okay. Extortion is to formulate a contract through illegal means with the threat of future harm. So one is immediate harm, the other is future harm. So, for instance, if I want your money, right, and I come up to you and I threaten you with a gun, I'm going to shoot you unless you give me your money. What you're doing is you're formulating a contract with me for your money. But the way in which we formulate that contract is through the use of threats, intimidation, coercion, duress from the threat of immediate bodily harm. You're not giving me your money because you want me to have it. You're giving it as a result of the duress that I've inflicted upon you. So that's a crime. It's robbery, and you'll go to prison for such crime. Okay. But the problem is that when it comes to extortion, as a prosecuting attorney, I have the power to send you to prison. I have the power to give you charges. I have the power to say whatever I want to say. If I were to say to you, if you don't enter into this contract with me to of your commission of guilt, I'm going to send you to prison for 20 years, right? It's future harm. And that is the crime of extortion. And what's really interesting, you guys, is that when you go out to the law of extortion, right, you read the statute under Title 18, down at the bottom of it, it says very specific things that would be considered a threat with regard to this particular statute. So, in other words, to formulate a contract through the threat of future harm, it needs to say, well, these are the things that would classify a threat under this particular statute. And what it says down there under item B is it says any threat of criminal sanction would constitute a threat protected under this statute. So if you are threatened with criminal sanctions, that is the crime of extortion written right in the law for all to see. No prosecutor can come up to you and say to you, if you don't plead guilty, I'm going to ask for the maximum punishment, because what they're doing is they're abusing their powers through the threat of future harm to get you to enter into a contract, and that contract is void because duress is a justifiable defense for a crime of breach, contract, or tort. Anytime you use duress to formulate a contract, that contract is fully void, fully breachable. So one of the things that my litigation is doing is we're looking at what I call the formula of intimidation. All intimidation follows this same formula. And once I say it to you guys, it'll make sense to you. Be like, oh my God, All intimidation follows this formula, and it goes like this. If you don't do X, I will do to you Y, whereby X is my envisioned outcome and Y, as a result, my powers can cause. So, for instance, I have the power to bear arms. If I go and buy a gun and I point it at you and I say, if you don't give me your money, I will shoot you, my envisioned outcome is I want your money. Result, my powers can cause that I will shoot you. The formula of intimidation has been employed, and thus the crime of robbery has occurred. Now, if I'm a prosecutor, I have certain power as well. I have the power to send you to prison, or the power to give you charges. If I employ the formula of intimidation, it goes like this. If you don't plead guilty, I will send you to prison for 20 years. My envisioned outcome is I want you to plead guilty. Result, my powers and cause, I'll send you to prison for 20 years. The formula has been employed, and it's the exact same formula, whether you're a robber or one committing extortion to get you to enter into a commission of guilt through an abuse of power. Nonetheless, crime has been committed, and by that crime, there is no judgment. The convictions are all void without force or effect.
Unfortunately, I mean, everything you're saying is spot on, but unfortunately, not so much that I've seen with the state, but with the federal government, going back to what you were talking earlier on about them never being meant to be, an overseeing law enforcement more in the states.
Yeah.
It's the feds who come in and do that. And I grew up in a family lawyer, so I have a good bit of experience in the legal field and have seen many cases. And normally, no, they don't come in and threaten you. They do it roundabout. They tell your lawyer in not so many terms, and that's, I believe that's why they have a 97% conviction rate right now because of that.
Right. Well, just remember, the law of witness intimidation and tampering says any direct or indirect threat. I can't call up my friend and tell my friend to tell the prosecutor's client, the accuser, that I'm going to shoot them if they come and testify, because that still is an indirect threat, right? It still causes them to take action to avoid delivering evidence to that judicial proceeding. I can't do that any more than a prosecutor can say to my attorney, well, you tell him that if he doesn't plead guilty, I'm going to send him to prison for 20 years. It is still an indirect threat, and that threat is still valid, right? Now, you know, we can argue the semantics, but at the end of the day, the plea bargains is absolutely a big part of what I'm arguing through the use of threats, intimidation, coercion, or duress. But the fundamental breakdown of due process exists when the state decided to proceed with the improper charging instrument in violation of the Constitution. That is what we're using on the case. These other things are things that I'm explaining on the breakdown of due process and how they get you to manipulate it so that you can operate in fear and comply with their desired results. But at the end of the day, the grand jury issue is an absolute slam dunk. And so today, as we speak, I have already served 47 state attorney generals with notices that their prosecuting attorneys are committing crimes. Right? They're depriving of rights under state statute, and that is a crime. So I provided affidavits to 47 state attorney generals. I did that over a year ago, and I asked them to step up and direct their agents to act in a lawful manner, consistent with the Constitution of the United States of America. When they failed to take action and correct these unlawful acts, they abstained and ignored it. Then I decided, well, I better go back and I better serve the Supreme Court then, because they're in charge of all the judges. So I went back and I served 47 state Supreme Court justices with notices and affidavits letting them know that their judges are engaged in a criminal conspiracy to undermine the laws of the United States when they conspire by and between the prosecutor to deprive of rights under color of law, right? And so I asked them to direct their judges to act in a lawful constitutional manner consistent with the obligations that they have. And when they chose to abstain, now we have a third branch of government, and I needed to get that third branch involved. Because every time I go to Washington, D.C., and I'd sit down with a senator or congressman, I'd say to them, well, your state has got a law that allows for your prosecutors to do this. It's depriving your constituents of fundamental constitutional rights. Every single one of them would say, oh, that's a state issue. That's not a federal issue. That's a state issue. We abstain from state issues. And I had to explain, like, this is not a state issue. When the federal constitution provides a limitation of power upon the states and the states create a law that abridges it, that's a federal issue. That's not a state issue. right? That's a federal issue and it's protected by the Constitution. But nonetheless, I couldn't get the legislative branch to engage in this because this is a big deal, man. 700,000 people currently imprisoned in America unconstitutionally. That's a big deal. And that's just the tip of the iceberg because we've got other major things that have to do with restoring families, getting children back home out of the CPS system. That's what my partner Jessica Saxon is doing. Amazing things with that. But ultimately, our litigation is focused on those two things: getting prisoners back home and getting children back home. Because every single prisoner is someone's child, and I guarantee you that those moms and dads want those kids back home so they can be healed from the trauma that this system has inflicted upon them, so they can advance their financial interests. But nonetheless, so I had to get the legislative branch involved because the attorney general is executive branch. The Supreme Court is the judicial branch. The third branch of government is the legislative branch, and I couldn't get them to actually step up and participate and provide the oversight necessary to make these other two branches obey the law. So as I met with your senators, because I guarantee you that I've met with all 100 senators and their agents, as well as about 230 of the congressmen in Washington D.C., and I'm going to tell you, not one single one of them have stepped up to do anything about this. Every single one of them said that's a state issue. We don't get involved in it. And so I had to find a way to force them to get involved, which is what I'm doing now. Is I'm traveling the country. I've been traveling the country for years, but I'm traveling the country once again, and I'm going into city council meetings and county commissioner meetings because the lowest level of the legislative branch would be your city council because they create the local legislation and they prepare the budget that pays for these government officials to do their work. So an emolument violation is when you pay someone to break the Constitution. You can never pay someone to break the law. That is a crime in and of itself. So if the police are going out and arresting people by way of information and not indictment in violation of the Constitution of the United States because the state law permits them to do that, that is still unconstitutional. And that city council is paying for that unconstitutional act to occur, for that crime to be committed. So the way that I'm forcing the legislative branch to get involved is when I go into a city council meeting, right, on public record, in official meeting, and I explain to them this is what the Constitution requires. This is what your state is doing. That's clearly unconstitutional, right? You guys are paying for that work to be done, which is a crime. So I'm asking you to step up, provide the oversight necessary to fix the unlawful, unconstitutional acts of the people that you pay to do the work. And if you do not, then criminal sanctions can now be brought against you. So if the legislative branch doesn't want to be involved in this because it's too big of a deal or whatever, that's fine. I'm just going to inform them that you don't have a choice. You are either committing a crime by continuing to pay these people to break the Constitution, or you better step up and say, either one, I'm not going to pay them anymore because I'm not going to participate in this, or two, I'm going to direct them to act in a constitutional manner, or else they won't get paid. Because if they don't do this, then they themselves are complicit within this conspiracy. So I'm using the emolument, I'm using paying people to break the law as a mechanism to force the legislative branch to step in because none of these county commissioners they didn't know that they were doing it. They didn't even direct the people to do their job. I get that. But if they didn't pay people to do that job, we wouldn't have any crime being committed against the people of the United States in violation of the Constitution. So the legislature needs to step up and do it, and that's why we've gone around the country. We've served 58 of these city councils and county commissioners, and the reason why we're doing counties, cities are easy. Police are paid by the city council. So if those police are committing crimes, break the Constitution, that's easy, right? County pays for the sheriff's department. They pay the budget for the courtroom because it's a county courtroom. So the resources that are necessary to be able to do the prosecution, and they pay for the county jail. So if the jail is housing people who have been arrested unconstitutionally, now the county commissioners are paying for that unconstitutional detainment to occur, and so now they are responsible for taking action once notified, because the law is a criminal conspiracy. What it says that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of the same, neglects, or refuses to do so may be joined as defendants in the action. So when I go into an official city council meeting or county commissioner meeting and I inform them on the public record that these crimes are being committed and you're paying for it, the question is do they have the power to prevent or aid in the prevention and commission of these crimes? And they absolutely do, because you pay those people for the work that they do. You pay for the resources that they need to facilitate these unconstitutional acts. So I'm going to argue that there's no, there's no county or jurisdiction in the country that I wouldn't be able to find 12 jurors that would disagree with me that there was something that these county commissioners and city councils members could do uh, to prevent these unconstitutional acts from occurring against their own constituents.
So really, I mean, you are really helping with an unjust statistic. And correct me if I'm wrong, but I believe the US houses around 5% of the world population, but we house 25% of the world's incarcerated population.
Absolutely. So here in America, we have 5% of the world's human population, 26% of the world's prison population. Here in America, we have 16 times more prisoners than the next closest industrial nation. Here in America, we have had an 800% increase in the prison population in 30 years. Here in America, ever since 1978, when the death penalty was reinstated, of the 1,500 people that our nation has put to death, 140 of them have been proven to have been innocent after they were murdered. Another 186 of them were exonerated after being placed on death row, meaning that they're factually innocent despite being found guilty by a system that doesn't give a shit about the other side of the story because they only care about advancing their own narrative. These are bad numbers. Those two numbers, 140 innocent people that were put to death after they were put to death, they were found out to be factually innocent. That's 18% of the people we've had on death row and put to death here in America were factually innocent. And that's just the ones that we know about because they still have evidence or whatever to be able to show that they were innocent. These are terrible numbers. And I want to bring attention to something else. If you were to go out and open up the Federal Criminal Procedure Manual, right? This is the Federal Criminal Procedure Manual. The preface was written by a Ninth Circuit Court of Appeals judge, so a federal appellate judge, very, very high up judge. He wrote the preface. And if you go to paragraph number 4 of the preface, what he wrote was most prosecutors across America agree that as much as 15% of the people in prison are innocent. But that is an acceptable deviance because our system isn't perfect. So we have a federal appellate judge that says most prosecutors across America think that 15% of the people in prison are innocent. But hey, that's just luck of the draw because our system isn't perfect. We have
I'd like to say something.
18%. We have 18% of the people that were on death row factually innocent, and yet they are put to death. I think that that number is much higher than 15%, but we can see actual tangible statistics to show that there is an inordinate amount of people that are currently imprisoned here in America that did not commit a crime or did not commit the crime that they were alleged to have committed or were framed or any number of other things. We know that there is an inordinate amount of people that are currently in prison here in America unconstitutionally that are innocent, and yet the system says, well, it's too bad. My challenge to the United States Supreme Court, for instance, on such a statement, and certainly that Ninth Circuit Court of Appeals judge is before you call something imperfect, I would first suggest using it the way that it was designed to be used. Don't blame it for your incompetence or don't blame it for your laziness, and certainly don't blame it if innocence is sitting in prison suffering here in America because of your incompetence. You're missing the first step. The one thing that our founders created to ensure that innocents wouldn't be in prison suffering was the grand jury, a fair and neutral decision maker that would review the state's case to make sure that they were not exceeding the power authority statutorily conferred upon them by the Constitution of the United States. If that proceeding was in place and properly used, we would know that innocents would not be in prison suffering because we would have a fair and neutral decision maker that's not attached to that's seeking the enslavement and forced involuntary servitude and financial interest of that enslavement. It is absolutely disgusting what America is doing. But this kind of ties back to the child issue with what Jessica Saxton is doing right now today. Right now, we have more than 12 million children that are in the CPS system, in state custody, right? 12 million children. It's well known that a child that grows up without the love of their mother and father, that child grows into an adult that has an 85% likelihood of going to prison over their lifetime because they don't know how to be a man or a woman. They don't know how to build relationships. They don't know how to live within the parameters of a society that has certain laws and limitations. We know 85% likelihood of going to prison for every child that you remove from love and care of their family. And then we wonder why we have mass incarceration. We wonder why we've had an 800% increase in prison population. Based upon the trajectory that America is on right now, 10 million of those 12 million children are going to end up incarcerated over their lifetime. 10 million of them. Today, right now, we have 2.9 million prisoners, and we're at 16 times more than the next closest industrialized nation right now. That means that in one single generation, based upon the track that we're on, by the trauma that we are inflicting upon these children through the destruction of the familial unit, removing them from the love and care of their mother and their father so that the state can financially benefit from them through Title 4D and these other financial incentives to remove children from families, we know that we could go from 16 times more prisoners to 58 times in one single generation. We're on an unsustainable track right now. These children, they need to get back home to their families. They need to get the love and support they need. And the states need to get out of the family business because they don't know better how to raise that child than the family themselves. The first act of our government should not be the destruction of the familial unit, the removal of the child so that you can financially benefit off of those children, right? The first act of our government should be the preservation of the family because the family is the most important institution within our system of government. Absent the family, we will see a destruction of our nation. And so you have a very, very short term financial benefit where states are actually incentivized to remove children through what's called the Title 4D and Title 4E payments from federal government to the states. But what we're not talking about is the long term financial incentive for every child that you remove from love and care of their family. That child then grows up, has an 85% likelihood of being forced into prison, and thus the state is going to enslave them, profit off of them, force them into involuntary servitude and for-profit businesses. This is a disgusting institution when you actually break down and understand the fundamental mechanics of it. It is horrible.
Didn't Ronald Reagan say it best? He said, when the government knocks on your door and says they can do something better than you, slam it and lock it in their face and go the other way.
Run away. Run
Yeah,
away. Yeah. Yeah.
absolutely. And just to touch down on a personal experience I had helping in the family law firm one time, and this is the mindset of these prosecutors who I very nicely called overzealous. There's plenty of choice words I could use. But we had a client who had been convicted on this new federal law that really was kind of hokey the way it was done, but then the Supreme Court ruled on it 9-0 against the government. And so we were trying to get them in the appellate court. We had everything, showing they were innocent. We called the prosecutor to try to see if there was anything so we wouldn't clog up the courts that they could do. You can obviously see that where this is going.
Yeah.
And verbatim, their words were, "We're not in the business of releasing people. We're in the business of locking people up."
Yeah. Yeah. It's so what I would say to that is that 9 years ago, when I decided I was on the wrong side and that the things that I was doing was wrong, that what I believed in wasn't real because there is no justice with a system that is wholly one-sided, uh, and justice is equally concerned about both sides. Truth will always allow both parties to speak, right? We don't have truth. We don't have justice. We don't have those things. Everything I believed in, everything I thought was real, I came to understand was a lie and it wasn't real. But it was through that suffering, it was through that experience that I realized that I don't have a choice in what I'm doing here. I know I'm right. 100%. I know I'm right. I know that the law is on my side. I know that God is on my side. And I can't stop doing this because I can never unsee something that I know is real. These people need help. And I may fail, right? The Supreme Court may never agree to hear this case, but I believe in it. I believe in it enough that I'm out here fighting for it every single day. I believe in it enough that I've given up my life to help the people of the United States and to even help those that are leading us understand their folly and their foolishness. Right? The Supreme Court needs to understand that they don't have the power they think that they have, and they are leading to the destruction and dissolution of this country because the only thing that makes America America is that Constitution of the United States of America. Nothing else does it. So if
Hmm.
we can't fight for the Constitution of the United States of America, we have lost our country. And I don't want to live in a world that doesn't include America. I will continue to fight for this until the day I'm proven a fool or the day that the court agrees to allow me to present this debate to them. I believe, I believe with all my heart, I would not be out here doing this if I didn't believe that this was going to work. If I didn't
So
believe that I
tell
could bring attention to this, I believe that the court is going to agree, and we're seeing a number of indications as to that. But my faith is what's driving me on this, and I'm not going to stop until I know that the people have been given the rights they were guaranteed 243 years ago. That this institution has robbed from them and decided to, advance their own financial interests.
well, tell us about your saying, one question, one action, every prisoner. Tell us what it means to you and what it should mean to every American.
We have one question that goes to that court, and that question is: can a state be both accuser and judge in the same cause? Right? That one question, affects every single prisoner, because in every single case here in America, every single prisoner was sent to jail based upon an accusation from an agent of the state, and then that state acted as the judge in that same exact case. Can a state be both accuser and judge in the same cause? The truth is that we only need one case to win. There's millions of people that could ask me. In fact, I've had more than 4,000 people petition the federal court on the work I'm doing. But we only need one case to overcome, because that's the power of Supreme Court edict. If I can get the Supreme Court to acknowledge their folly, right, and acknowledge what they did by through a completely biased and unjust and slave owning, desiring the advancement slave owner court back in 1884, if I can do that, right, then one decision will overcome every prison. This is a fight. This is a fight for the restoration of families. This is a fight for the restoration of justice, and this is a fight um, for every single prisoner. And there's lots of different types. Children that have been taken into state guardianships, those are prisoners. They are prisoners of the state. There's prisoners that have been accused of committing crimes. They are prisoners of the state. I don't think the state was ever intended to be in such a position where they're able to profit financially off of uh, the removal of the freedom, happiness, and everything else. Put them into an institution that's actually going to hurt them more than help them. Um, this is a tall order. I get it, but we got one question, and I have one action, and this is going to ultimately affect every single prisoner, no matter how old they are.
Okay, so what we said earlier about ambiguous laws and bureaucratic overreach and judicial activism. This kind of resonates with your statement about the executive branch writing policy as a means of clarifying ambiguity in the law and
Yep.
then directing its agents to go out and enforce the policy. And you say this means the executive branch was being permitted to amend the law despite having no constituted authority to legislate in any manner. So, can you explain this to the audience?
Yeah. So what you're referring to is the Chevron deference. And on June 16th of last year, 2024, the United States Supreme Court overturned a 40-year ruling that had to do with what's called the Chevron deference. And so what happened there was that when the executive branch, when they read a law and they believed that it was ambiguous or it wasn't clear or whatever, then they would write policy to clarify the law, and then they would go out and enforce the law according to their policy, right? And they did this for 4 years, right? And so For instance, when you consider that there's been an 800% increase in the prison population in 30 years, I wonder what led to mass incarceration, but for prosecutors who are part of the executive branch writing policy that because they said that the law wasn't clear, such as the Fifth Amendment, where it says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. When a prosecutor says, oh, that's not clear, that's ambiguous. Therefore, I can choose to go this way or this way, charge by information or indictment. Then we wonder why we had such mass incarceration occur, but for the arbitrary and capricious ambiguity created by prosecuting attorneys all across the country, where they said, "Well, we're free to be able to write our policy and do whatever we want." The problem is does the executive branch have the constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution? Does the executive branch have the constituted authority to legislate? That's the exact same issue. I'm dealing with the judiciary. Last year, we dealt with the executive branch. If we want the Constitution back at the foundation where the people need it to be protected, we have to remove all the bullshit that the executive branch created, that they erroneously called law or treat as though it's law when it's just policy. And we got to remove all the bullshit that the judicial branch created that is rulings that they have erroneously called law. And when we do that, then we'll see the Constitution fall back into place. Last year, the Chevron ruling overturned the 40-year Chevron deference, where the judicial branch allowed the executive branch to amend the law through the writing of policy and then go out and enforce their policy as though it's law. But that was a successful challenge, and that was the first part of what I was trying to do. Chevron was largely overturned because of the work that I was doing by notifying the attorney generals that they are acting unconstitutionally. Your attorney generals are following policy that tells them that they don't have to follow the Constitution. But once again, executive branch has no constitutional authority to be able to amend the law. If you're not clear, executive branch, on what the law requires, then I would suggest that you go back to the branch that is constituted with the authority to amend the law, get clarification from them. Otherwise, what you've done is unconstitutional.
See, we believe that the root of the problem is the centuries of overly ambiguous laws passed by the legislative branch. And that's why we're going to tackle it from right now. We're starting by promoting media literacy and political awareness, where we're demanding truth from the media and one administration to go in and do everything humanly possible to put out policies and legislation that abide by the Constitution, because we believe, the true change starts at the top, starts at the bottom, meets in the middle. So,
Yeah.
secondly, I didn't realize this until we were doing research, but less than, and I tested it out on some very educated people. Less than 1 in 5 Americans, adult Americans, can name the 3 branches of government. So, we're going to do a nonprofit and start trying to teach our youth, high schoolers, how to hold their politicians accountable. And then we're going to start challenging some of these unconstitutional laws in federal court and push for legislation requiring an independent constitutional review of all new and existing laws, because it's time to hold our leaders to the oaths they swore.
Yeah. And I agree. I agree wholeheartedly. There's a multi-pronged approach to what's happening. I know I'm a part of it, but I'm not the end of it. What I'm doing is I'm attacking the judiciary for
Oh,
243
absolutely.
years of them believing that they get to make the law. Judicial branch, you don't get to make law. Every single thing that you created, right, that you called case law is not law, because judges cannot legislate. It's all bullshit. But you're right. The 3 branches of government, the people of the United States needs to understand, because most everything that I argue has to do with separation of powers. The first branch of government, Article 1, legislative branch, that they're there to create law. That's all they do. They create law. All legislative power is vested in Congress of the United States, consisting of a Senate and House of Representatives. Legislative power is the power to create law. We delegated the power to create law to the legislative branch. Now, I agree that much of the legislation is unconstitutional. I'll come back to that in one moment. The second branch of government is the executive branch. Their purpose was to enforce the law. They are the law enforcement branch, but they don't create law. They create orders, executive orders. They create policy, right? But orders is not law. Orders the people don't have to follow because the people are only subject to the law. Orders only affect those that can be ordered, members of the executive branch. Orders don't affect the people. When the president creates an executive order, that is not law, that is policy, right? And that only affects those that he governs because the president doesn't govern the people, the president is subject to the people. So the second branch of government, executive branch, they're there to enforce the law. They create orders, not law. Third branch of government is the judicial branch, and they're there to administer the laws. They're the administrative branch. So they create rulings. They don't create law either. They create judge-made rulings, not law. But when they create a ruling, right, that amends the Constitution, such as they did in 1884, when they said you don't have to do what the Constitution requires you to do, California, they created a ruling. And that ruling they erroneously and unconstitutionally called law. But guess what? Judges cannot legislate, right? Because all legislative power is vested in the Congress. So what Chevron did was Chevron addressed the first part. Executive branch, you don't get to create law. Chevron deference says you don't get to create law. Your policy is all bullshit. Get rid of it. Make it go away. I'm dealing with the second half. Judicial branch, you don't create law either. And this is a big, tall order, but it is 100% valid because judges make rulings. They don't amend the law, right? They can't change the Constitution. And if you call your ruling law, well, that means you just legislated. And judges cannot legislate. It's a separation of powers issue. So all the rulings that the Supreme Court has created that amended the Constitution, such as from Todd over California, and there's a few others, get them out of there because judicial branch, you don't have the authority to legislate because we, the people of the United States, we did not delegate such authority to you through the Constitution of the United States of America. That is a limitation of power through the separation of powers, and uh, and so I'm going after the third branch of government to hold them accountable. Now, the last thing I want to say is this, because you're right on the legislation. I have three master's degrees. One of them is in substantive law. I got it from the most expensive university in the United States, where I graduated with a 3.98 GPA on the South Lawn of the White House. I know substantive law as well as anybody in this country, right? Which is Constitution, right? I know the Constitution is better than just about anybody. I am not an attorney because I'm not going to take the bar. I'm not interested in their institution. I'm here for the people of the United States. I enforce the law. I don't administer the law, right? Big difference on those two. But my point here is this um is that uh, um I just lost my train of thought on that. Um
It's okay. I'll go with something and maybe it'll jog you up because I love what you're doing. It's noble and like I said, it goes hand in hand with what we're doing and our approach. But another
oh
issue with these ambiguous policies is they are given to federal agencies. The lawyers representing those agencies then ambiguously interpret the already ambiguous laws to favor them towards the agencies in their policy statements, and then mid and upper level management each has their own ambiguous interpretation of the already ambiguous policy statements. Everything is getting so muddied and eroded and unconstitutional. We have to get back to our strong foundation before everything comes crumbling down.
yeah. And the strong foundation is the Constitution of the United States of America. That's the only thing that made America. Which was what I was meaning. The point that I was trying to make is that I have a lot of education. I've spent a lot of money on school. If I could sum up if I could give your audience just a summary of that education and the most powerful things they can take away is this. And when you grasp what I'm about to say, when you fully grasp what I'm about to say, uh, the power that you're given is immense. Anything that is not the Constitution is unconstitutional. Simply by virtue of the fact that it is not the Constitution makes it unconstitutional. Nothing that is not the Constitution can be constitutional. That doesn't matter if it's a judge made ruling, doesn't matter if it's a state statute, doesn't matter if it's a policy. Anything that is not the Constitution is unconstitutional. So when I prepare an argument or when I try to give people advice here, What I say is go to the Constitution of the United States. What does it say? Because anything else is unconstitutional. If the Constitution says no person shall be held to answer for capital or otherwise infamous crime unless on presentment or indictment of grand jury, then when that court says to me, Hurtado versus California, 1884, all I have to do is say, no person shall be held to answer for capital or otherwise infamous crime unless on presentment or indictment of grand jury. That's constitutional. When they say a state statute says they don't have to do it, I'm going to say the same thing. No person shall be held to answer. Right? When they tell me the rules of civil procedure, I'm going to say no person shall be held to answer because I'm standing on the highest form of law. And I'm not going to come down off the highest form of law to argue in the weeds in the bullshit that is not the Constitution.
Mm-hmm.
The judge made ruling is not the Constitution, right? Therefore, it's unconstitutional. I'm going to rely upon the words of the Constitution. I'm going to argue it, and I'm not going to come down off of it to argue anything that is unconstitutional simply by virtue of the fact that it's not the Constitution.
Let me give you you and the viewers and audience a disturbing statistic. And I didn't realize this either, but a pretty reliable poll came out the other day. And do you realize that 1 in 3 Americans now believe it's going to take violence to get us back on track?
I do, but I'm disagreeing with that. Uh,
Absolutely.
I'm disagreeing with it for one very very particular reason. Uh, so I'm as much a patriot as this country has ever produced. I'm very proud to say that, right? I love this country, and a patriot is defined as one who loves and defends his country, right? But the problem is if you love something, destruction can never be an optional outcome for that that's loved. I don't want my country destroyed because I love this country, and I don't want to see destruction come upon that I love. But if you say that there's other options, let's go get guns and arms and let's fight this battle and let's kill 1 million people of our brothers and sisters in another civil war. I'm going to say that that's not love of country. That's not patriotism because the way that you treat your fellow man is a direct reflection of how much you love your country. Because America is nothing more than the aggregate of the people. So I want this to come in the most peaceful way. I'm trying to avoid the train wreck that is potentially coming because I do understand there's a lot of people that are seeking violence right now. And I don't want to see that happen. I don't want to see any more losses of lives. That's why I'm appealing to this institution and trying to get them to understand that there is some very, very dangerous shit coming their way. And I don't want to see that happen, right? I want them to step forward in truth and work with me to avoid that. But the only way that that's going to happen is if they come to terms with the fact that you're obligated by law to do it. And a criminal is defined as one who transgresses the law. And if that law is the Constitution and you government are transgressing it, you're the criminal. And the people are actually lawfully able to do things to you that you don't want to have happen to you. And that's not what I want to see. That's what I'm trying to avoid. I want these public officials to listen to what I'm saying, recognize the limitation of powers that they have, and step back to lawful side so that we don't have such destruction come upon this nation. I want to save this country. I don't want to see destruction of it.
We wholeheartedly agree at the Patriot Party, and that's why we say we're offering a non-violent reset for the country. It needs a reset. We need to get back to our founding principles, is what the reset needs to be. This is a little bit off topic, but you seem like the perfect person to ask. How do you feel about lifetime appointments in the Supreme Court?
So uh, the problem is that our system of government, the whole premise behind it was that our public officials would be subject to the people. You know, uh, and so when you have this institution that is not subjected to the people, then they're able to do whatever they want, whatever they want, anything that they want at all. No, the judicial branch is absolutely subjected to the people. You can have a lifetime appointment as long as you're acting lawfully, but if you're not acting lawfully, you don't have a lifetime appointment. The Constitution doesn't give you the ability to break the law. Sovereign immunity does not give you the ability to break the law, right? Every single person within our system of government is subject to the crimes they commit. If you go out and you read absolute immunity or judicial immunity or prosecutorial immunity, what you'll find is that it says immunity from civil liability, because criminal liability and civil liability are different. There was a case from 1980 or 1978 called Imbler versus Pac-Man at the United States Supreme Court. And what it said is it said that even judges cloaked with absolute civil immunity for centuries can still be held criminally liable for willful deprivations of constitutional rights. Judges are civilly immune. You're not supposed to sue them, but they are not criminally immune. If a judge commits a crime, that judge is done, cooked, and is subject to the criminal conduct that they commit. So the whole argument on this whole lifetime appointment, I would agree that perhaps the lifetime appointment might be beneficial, but that doesn't mean that they are immune. If Thomas and Gorsuch and Sotomayor and Barrett and Roberts do not take up this case when I return to Washington, D.C., and deliver this to them, despite being made aware of the unconstitutional and illegal acts being committed by their agents under their watch and their authority, then that treason is on them. And they're not immune from liability of that of such treason. Because when the Supreme Court of the United States fails to preserve, protect, and defend the Constitution of the United States of America, the one thing that their institution was created to do so, when they choose to ignore it or not enforce it, they've just destroyed their institution. And so I think that when you look at the lifetime appointment, there's a difference between being appointed for a lifetime to be able to make good judicial decisions and be out of um, um, pressure from other branches of government, but there's something completely different, that you are still subject to the people, and you don't get to make decisions that are contrary to the people's best interest. You don't get to make decisions that are contrary to the law, because you judges, including you Supreme Court justices, are all tethered to that positive law created by the people.
And you're talking about our politicians and our government being subject to the people. We have people with so much hubris right now, like Senator Tim Kaine, literally saying that the rights are granted by government, which is it goes against everything that this country was founded on. That's the same mentality as the monarch before the American Revolution.
Yeah, that's insane. Because before the government was created, the rights existed, right? So Tim Kaine is absolutely mistaken, because we, the people, in our sovereignty, created the Constitution, which preserves the rights by creating the obligations of government. That's what created government. So government is a creation of the Constitution, and the Constitution is a creation of the people. Therefore, for Tim Kaine to say that the government gives the people their rights is like saying that the peasant is above the king. We are the king. We are the sovereign, not you, government. You are a creation of ours, and that which is created cannot be above the creator. That's a very simple creational rule.
You
We, the
serve
people, created.
us.
Right, absolutely.
Yeah, you
So for
serve
Mr.
us, and I mean
Kaine,
that goes against the spirit of the founding fathers in the Declaration of Independence on unalienable rights granted by your Creator. And I mean, it
right,
doesn't matter if you're an atheist; you can think those rights were granted by your mom and your dad. I mean, that's science, but they were granted by your Creator.
but they cannot be granted by government,
No,
because we, the people, created the rights before the government existed. Here in America, there was no government when our founders went into the Constitutional Convention, created a constitution, and then ratified it through the states. As of that moment, nothing existed. Well, the previous form of government, the Confederacy did, but the moment that a new government was ratified, a new creation was created, and that new creation didn't exist before the people created the rights. Government doesn't give the rights. The rights were created before government. Therefore, government to claim the rights would be, again, like that which is created, saying, I'm in control of the creator. We, the people, are the creator. Government, you are the created. You don't get to be above us. We are above you. You don't give us the rights. We protected them through the laws that you're bound to follow. I mean, this is all simple stuff, but for some reason we have a bunch of fools and I have no problem calling him a fool, and he getting dangerously close to traitor at that. But I'm gonna say he's a fool, making foolish statements such as that, and we just need to kind of clarify the foolishness because that's all that is. For one of these public officials to make such a statement, uh, that's a very, very dangerous position for Mr. Keynes to take against the people of the United States. A very dangerous position, and that's just the type of position that I want to warn all of them to return from because if they don't, I can't control the people and what the people are going to do because at some point in time, the people are lawfully able to take action against you, traitor, right? When you fail to follow, and they are lawfully justified in such action. I don't want that to happen, right? But you all need to wake up, senators, congressmen. You all need to wake up and you need to realize your role within the system of government. You need to understand that there is 40,000 judges across America that is destroying lives and families and locking innocent people up. We have 330 million people. What are those 330 million people going to do when they hear what I have to say about what you've been doing for 243 years by stealing their rights that they're guaranteed and locking innocent people up and stealing families and children from loving parents? What are you going to do, right? 40,000 judges. This is the,
You know,
the, the train wreck you're facing here.
absolutely. And you say the only title you carry now is servant. I wish more politicians felt that way, man. That would make our jobs a lot easier.
Yeah. So, in the past, uh, in the past, I made a lot of money. Again, $870,000 a year, and I could do anything, and I wore all these titles. Chairman of this, and chief architect of that, and CEO of the. So I had all these titles, logos, and I just kind of woke up one day and I'm like, I carry this title of husband and father, and I'm failing miserably on it because all I do is work. I'm a terrible example for my son. I'm not proud of what I'm doing or who I am. I'm not leading him right. For my daughters, I'm not being a good example of what a husband should do. Therefore, I'm not showing them what they should be looking for a man to give their hearts to. I was not being a good husband or father, and I was not fulfilling those particular titles. So I knew back then that if I'm going to be proud of the man that my son becomes, I must first be proud of the man that he emulates. And if I'm going to respect the decisions that my daughters make when they give their hearts to a man, I first need to be the type of man that I would approve for them. So the reason why I say servant is because 9 years ago I gave up those titles because I wanted to be the example for my own children that I needed to be by becoming the man that I was created to be and that I was falling short of. So when I decided that I don't need a title, I don't need a logo, I don't need a big law firm behind me. I don't need people to say CEO of this or CEO. No, I'm a servant to the people. That's all I've ever been. And if the people like the service that I'm providing, then they're going to make sure that they put me into whatever position best suits me. But I have served this country faithfully every single day of my life since a week after I turned 17 when I joined the military. I have faithfully served this country. I did it in my ignorance for a little while around 9/11, but I've returned to true knowledge of our system of government, and I'm just trying to help the people of the United States get protected and undo the things that I myself helped build in my ignorance.
So
So
first, on
I
behalf of
have
the Patriot Party, we'd like to thank you for your service. That's Thank you for being serving us like you did. That's very noble, very noble.
it's been a real honor, Matt. But
Um,
I do have to run. I've got a meeting that I got to get down into Tampa for that we
okay,
scheduled.
that's fine. If you'll just give me just one sec to wrap this
Yeah,
up, and
yeah,
then we can chat for 30 seconds or something afterwards.
sure.
And is there anything that you feel like we missed? I know I was getting ready to go through the "We Shall Be Free" tour, but if you got to wrap it up, is there anything important that you think we missed that you'd like to tell the audience before I wrap it up?
No, no, no. I think we covered the whole gamut of stuff. But your listeners are probably gonna have to watch it a couple times to try to soak up whatever's there. And I'd be happy to come back on. It's just that I wasn't sure how long this was gonna be, and so I set up another meeting down in Tampa for right after
No,
this.
no, no, no. Just give me a couple seconds. I'd like to run something by you before you hang up, and
Yeah.
then I'll let you be on your way. So just hold on one
Okay.
sec. Let's all thank Mr. Tanawah Downing for joining the Patriot Party. And to all of you out there, stay safe and don't forget to catch our Saturday morning show at 10 a.m. Central Standard Time, where truth meets every corner of the news.